Again, good afternoon, everyone, and I would like to welcome all our new attendees and thank our regular attendees for being with us during our weekly events. Today's webinar is on legal protections for property investors in Dubai, presented by Veronika Chastukhina. Veronika, good afternoon. Just a quick intro on HAQQ and My HAQQ, which replaces all the apps you have in front of you and saves you up to $15,000 per user per year, which you can attract more clients through while saving operational costs. You can always register through lawyer.haqq.me. Our partnership ecosystem expands through different sectors: software, community, and media and distribution. We have partnerships with both the Beirut Bar and Tripoli Bar Association, LexisNexis, Middle East, Lebanon Law Review, NVIDIA, and many other platforms. Our CEO and co-founder is Antoine Kanaan. He exited founder and editor-in-chief of the Lebanon Law Review. He's an executive board member and director of global partnerships at Emirates Legal Network. Co-founder and Chief Legal Officer, Matter Abbas Kabalan. He's a PhD candidate in financial markets. He is the founding and managing partner of Kabalan and Kabalan Attorneys. We have a board of directors which is diversified across different academic backgrounds and professional backgrounds. We have Dr. Anatoly, our chairman and a professor. He's also director of European Investor Relations at BLBG, Ramzi Farah, Mauro Romano, and Shazam. Lastly, HAQQ's community. We hold the largest legal tech conferences. Our top priority is fostering an informed legal community through multiple legal events every week, giving you a chance to grow and connect through our webinars, interviews, and our conferences. Today's speaker is Veronika. As I previously said, Veronika is going to be presenting a session on legal protections for property investors in Dubai. To introduce our speaker, Veronika is the legal director at Nagar Partners. She has over 15 years of legal experience. She has held roles as legal advisor in the United Arab Emirates and Africa. She's specializing in real estate and telecom. Her expertise include contracts, compliance, and multinational frameworks with a focus on the UAE laws and international business. Welcome, Veronika.
Hello, everyone. So I will skip that presentation about myself, and I think we should go directly to my presentation, as it's pretty long with a lot of information in it. So I will skip this part. I hope everybody can see the slides properly. First of all, I would like to speak about why is it now so important to invest in real estate in UAE and specifically Dubai. For expats and residents, and for the local people as well. As you know, on the 2nd of December, we were celebrating the 53rd National Day of UAE. And if you will look back through these years, you will see how much work did the UAE government within only 53 years. It's a vibrant country, it's multinational, it's very modern, it's moving forward very fast. We have a lot of opportunities here for different businesses, including the real estate market, which is booming right now and already going up for a few years. Not only we have a lot of new off-plan projects, but we also have the rent, which is going up. And for the investment part, it's important that you are sure that if you will invest for the future, you can sell the property higher or rent it out for a good price. And it's also tax-free in the real estate sector for investors. And in my opinion, is one of the best locations to live and make your own business and build your future. Talking about Dubai and the regulatory framework here for the real estate, there are two governmental organizations, which is Dubai Land Department and Real Estate Regulatory Authority, who are passing all the rules and regulation, introducing them. But also we have numerous rental property laws, which covers the information and relationship between the landlord and tenant. Very easy to find, easy easy to read. Everything is in English with all the updates. You can even find easily online while you Google it. We then have a Dubai strata law for jointly owned property, which is managed by an owners association. It's usually built out of 9 people who already holds a property in the same building, in the sharing building. And we have an inheritance law, which is also important to remember about, because it includes the real estate property and how can somebody inherit it, or how to pass it to somebody else, which law you need to use. Will be a Sharia or the federal law, or you can apply your country law, but then you need to go through different difficulties related to the court system. The purpose of this presentation is to give as much information as I can with the timing about the laws, rules, regulations, help to avoid fraudulent transactions, following anti-money laundering laws, how to act if you are an investor with a developer, with a broker, which documents you will need to go through, review, and sign in the future if you're a potential investor. What do you need to understand? What do you need to keep in mind? Where to be careful, and what to expect from the developers and brokers. Going straight away to the legal due diligence for off-plan projects. The off-plan projects are those ones which are under construction or even not built yet, but they are on the paper. And here you are dealing directly with the developer who is presenting this project. There are 4 main things which you need to remember and look at. We will start with the developer's registration. So the developer must be registered with ARERA and have also the developer's license, valid one, which is very essential. Then when the developer starts a project, he or the company must register this project with the Dubai Land Department, and such project will have not only the name, but a specific number assigned to it as a registered project. And you can find information on the Dubai Land Department easily about this project, which stage it's on, and also information on, let's say, escrow account, which is also must be assigned to specific project. Each project in Dubai must have its own escrow account, and it can be only one escrow account for one project. There can't be multiple escrow accounts, multiple projects which have the same escrow account. And the point number 4, you will be working with the contract, sale and purchase agreement, and it's very essential to look through the points of sale and purchase agreements. The completion timeline is essential because you need to understand when your property will be ready for your use or sale or rent. And very important part is the penalties for delay, which I will talk about later in my other slides. If we are talking about a ready property, a secondary market, what do we need to understand here, and what kind of documents do we need to look at? First of all, the owners of the ready property must hold a title deed, and this title deed must be valid. It has a specific number and QR code at the bottom, which you can scan with your phone camera, or you can check on DLD, Dubai Land Department website, inserting the number of the title deed, which will show you the exact information on this property. Second point is you need to investigate on the service charges and see the maintenance history to understand the annual cost, because when you are buying the property and you becoming the owner, in each building there is a management company, and you will be forced to pay the service charges every year, which is usually split and paid quarterly, but it also depends on the management company. So for your understanding, you are not only buying the property, but every single year you will need to pay not a small amount of money, I would say, depends on the property and the location, but this must be taken in consideration. Plus, you need to see if there was some maintenance history, something have been done or not, and maybe you will need to participate in that by yourself with your own money. Then you need to verify if there is any mortgages or encumbrances attached to the property. because the way of sale and purchase will be a little bit different. The documents you're going to be signing will include the information that it's mortgaged. Actually, you can also check this straight away through the DLD website, because it will show you if the property is mortgaged or not through the title deed number. So then it will change a bit the structure of sale, and it will take a little bit longer, because the bank which gave the mortgage to the seller will need to provide some documents to approve. And then when you're going to pay, you will have few checks, one to the seller, the other to the bank for the outstanding mortgage, and surely the Dubai Land Department fees. Very important, before signing any agreement on the secondary market, you need to conduct a physical inspection of the unit or villa, or if it's a full building, to see in which conditions it is. And the suggestion here is to hire a snagging company which has a license mentioned in the activity as a snagging company, because here are some companies who are doing, let's say, painting or just small things in the apartment, and they can tell you, yes, we are doing snagging, but at the end of the day, you will end up with a one-page document which has 10 sentences, and it will not help you anyhow. To understand better what is the real snagging company, first of all, they have a license allowing them to do snagging. Secondly, their report usually looks about 10-15 pages with the pictures of every single spot which is damaged or need to be replaced. And they also give you the exact amount, probably precise amount, of how much money you're going to spend on fixing all of that. So that is a real snagging company report, which you can then use. And if you, let's say, want to reduce the sale price and discuss this with the owner of the property, you can tell him, this is the amount which I will need to spend after I will buy this property from you. So please, maybe we can renegotiate the amount of payment, the full amount, and take it down maybe. And the last but not least important topic here, the question, is this property is rented or not? I saw a lot of cases here when people were buying their property and they didn't know it was rented out, or the seller said that he already gave the eviction notice, but he didn't, or he made a mistake in the eviction notice. And then it's impossible to, almost not impossible, but it's possible, but it's very difficult and a very lengthy process to evict the tenant from your apartment, which you bought, and probably you were thinking to use it for yourself, and now there's somebody living there. Also, this information will go in your sale contract, which I will explain what it is. It's called Unified Sale Contract F, prepared by the government of Dubai, by DLT. So let's not stuck here. Let's go to the legal due diligence when hiring real estate brokers. So not only you're gonna work with the developer and the seller, but you, in all the cases, you're working through the brokers, and the legal structure here and legal documents are very essential. We have brokers and we have brokerage firms where such brokers are working. So what do you need to ask the broker as a person? If he or she has a RERA broker card issued in Dubai, because right now we're talking about Dubai. All the brokers must pass the exams in RERA, and after that they receive a broker card which needs to be renewed. This broker card usually includes their name, BRN number, and QR code. So you can scan QR code and see the validity of the broker card, or you can go to Dubai REST application and check the validity of their card. Are they actually real people, or are they registered, or it's a fraud and the document is fake? For the real estate brokerage firms, they will have a license allowing them to sell, buy, rent the property. So there are different activities. You need to understand this as well. Maybe sometimes some companies don't have an activity, which maybe you will need. So always ask for a copy of license of the company, which is valid for 1 year, need to be renewed every year. And if the company refusing to give you a copy of their license, this is a red flag. The key questions to the brokers. You need to understand that you will be paying a commission for their work. So you need to be sure that they have a right to sell or rent whatever property. They have a specific documents in place. If we are talking about off-plan projects, then first of all, the real estate broker company must have a contract signed between the developer and them, or if there are cases when one broker or one brokerage company, they have exclusivity on the project, and then developer allowed them to sign sub-broker agreement. So then it will be sub-broker agreement and the agreement, exclusivity agreement between the broker and developer, allowing them to sell the properties, the units, on specific prices and specific terms. For the secondary market, here we need to be very careful. Secondary market, first of all, there should be a document between the seller and the broker. It's called Form A. When the seller is selling his property, he signs a Form A with the broker, which allows the broker after that to place the information commercial about the property online and work with the seller and sell his apartment or her. If we are talking about the buyer who wants to buy the property, then it's a contract Form B between the buyer and the broker, which will include the broker's commission. And this is the final document, so you cannot say after that, oh, can we reduce the commission? Because you already signed that. And point number 2, secondary market in each emirate is working in a sale process in a different way. So if, let's say, there is a property in Dubai on the secondary market, but I'm a broker from Abu Dhabi, registered broker from Abu Dhabi, I cannot sell the property which is located in Dubai on the secondary market. I can sell off plan, but not the secondary market, because in Dubai, when you're selling on secondary market, you will need to go to trustee office to register title deed, and the broker from Abu Dhabi cannot help you to register title deed at trustee office. Only the broker from Dubai can do this. So it's a little bit of a difference. And then you also need to discuss with your broker what will be included in their commission: consultation, negotiation, delivery. You're not supposed to work directly with another party. If you are a buyer, you're not supposed to work directly with the seller, negotiate all the information, trying to bring the deal in the loop. So it's the responsibility of the broker, and this is what you're paying for. So be aware of that, and be sure that the broker you are working with will be at the closure of the deal. So the delivery, either we're talking about sale and purchase, or we're talking about the rent, they need to finalize the deal, and only then you pay them their commission. So if you go to trustee office, you have an extra check for your broker. As soon as the deal is signed there and it's closed, you give one of the checks to the broker for their work, not before, not splitting in any halves, right at the end when they already performed their job in full. About the commission charges, in Dubai, we have a maximum commission fixed fee of 5% from the total price of the property, but it can be less if you will negotiate it with the company, but it cannot go above 5%. And again, ensure that the commission is agreed in writing. As I already mentioned, we have a RERA Form A and RERA Form B between seller and broker and buyer and broker, which must be signed from both sides and have exact details of the property and the commission. So then there will be no questions or misunderstanding between you and the broker you're working with. Moving to legal review of contracts and unit conditions. I will start with the off-plan projects. Here we will be looking at sale and purchase agreement. Surely it's a very big document, and if you are buying from the developer, I will suggest you to work directly with the lawyer, even if you're an English-speaking person and you understand it correctly. But the SPA is very complicated, complex document. Sometimes it can be 30 pages, can be 60 pages, depends. And the lawyer will help you to highlight the risks and explain your responsibilities and responsibilities of the developer. What is important, essential in the SPA? First of all, terms on handover. When will be the property handed over to you? Normally, when the developer finishes the construction, they will receive a certificate, and they will give you 30 days notice in advance that you have a right to come with the inspection before you sign the handover papers and check any defects. So then you can negotiate with the developer and tell, okay, this there are some issues. We saw this and this and this and that. So let's work through this. If you will not use this 30 days before the handover, it will be expected and decided by the developer that you agree with everything, and then you cannot come back after that with some complaints. Then a very important thing is defect liability period. We have 2 defect liability periods. There is one related to the whole building, the full construction defects, like let's say in the wall, which is normally 10 years from the day of completion. And we have some manufacturing defects, let's say pipes, plumbing. So for this, you have 1 year from the day of completion. So if you should not be scared to say to the developer, listen, there is a leakage and I changed the pipes few times. So there is an issue with that, and we need to work on that. And the developer must use this defect liability period and help you, so you will not pay from your pocket. Also, what very important is the completion timeline, as we want to understand when the project will be finished. There is an estimated completion date in each and every sale and purchase agreement, but you should not take it as the final date. It's only estimated. So the UAE law gives the right to the developer, and normally in every single SPA, you will find the developer gives themselves an extra 12 months on top of the anticipated completion date as an extra time, which is not considered as a delay, and they will not pay any penalty, and the UAE law agrees with the same. So you need to be aware that that might be delayed by 12 months. There is other option or other situation, I would say, which started to happen from time to time here in Dubai, when the anticipated completion date was, let's say, next year, and suddenly the developer finished the construction 6 months prior to that. Look at your SPA. It also says that if the real completion date became earlier than the anticipated completion date, you will be forced to pay all the outstanding payments as per your payment plan. So you need to be ready for this and see if you will be able to pay. That's very rare, but it happened in my experience already about 5 times. And the important part is the verification on the penalties for breach by either party, because it's not governed by the UAE law. What will be the penalty? What will be the percentage, let's say, for the late payment by the purchaser? So the developer can put any amount they want, and you will be forced to pay. You need to look at this part specifically and decide for yourself, are you ready to pay this amount? Do you have actually a specific amount of money which will help you to go through, and how fast, as per the payment plan, will you be able to pay? So if you understand clearly that this is not the way you can do, don't sign the SPA. Also, on the market, there is a practice that you cannot resell your off-plan property and before you pay 30 or 40% from the total price. So if you don't have a 30 or 40% from the total price to be paid, don't go in this contract, because then you will not be able to sell it. You will not receive an NOC from the developer, and you don't have money to pay. And then you will receive a super small amount, or maybe you will not receive anything at all. Depends on which level is the completion of the construction, and it will be a long court hearings, and you might not get anything at all. So be very cautious about the payment plan and the penalties for you if you are going to delay those payments. About the snagging, I already spoke. For the secondary market, we have snagging. For off-plan, I talked about the defect liability period, which is 1 year and 10 years, and warranty coverage. Warranty coverage will be probably only on something like appliances, like fridge or something, but then it's not the developer's responsibility to cover that. So I think we can skip this slide, as I already talked about the inspections. We're going to legal responsibility to prevent fraud and financial crimes. As an investor, you should also think about how can you avoid difficult situations or fraudulent situations. So as was mentioned already before, you must be cautious. You must check the developer's license. Use the DLD or RERA platform to verify the developer or seller and also the broker. Then try as much as possible to avoid cash payments. If it's impossible to avoid the cash payment, never give cash, if we're talking about secondary market, to the broker. If you need to pay in cash whatever amount of money, you need to go to the real estate firm, broker's real estate firm, go to the accountant, give them the cash, they will give you the receipt. Same with the developer. So if you need to pay to developer in cash, you go to the accountant department and you must have a receipt with you, because there were also there are some unscrupulous individuals here who are making a fake broker card. People don't know about scanning, don't know about BRN number. They give them the cash, they go on the plane and they leave the country. But if you have a receipt from the developer or from the real estate brokerage firm, they exist. This is a corporate bodies which exist in UAE, and you can sue them if you will need. And one more important part, as an investor, always think about and remember about escrow accounts. So for off plan, there always should be an escrow account, and you never pay any amount of money to the corporate account of the developer, because then it will be also very difficult to take it out and make any claims on that. What can be the red flags for you as an investor, where you can just think, okay, I will not gonna go for this deal? First of all, you can see some unusually low prices or a big rush in the deal. Let's say the seller will tell you, oh, this is the agreement. If you sign it right now, or if you will not sign it within this 10 minutes or 1 hour, I'm going to sell my property to somebody else. This is a red flag. You don't work with this person and don't do any deals in the future. Unauthorized brokers or developers who have no license and they're not listed. And again, we are scanning the QR code on the broker's card, and if there is somebody else's name, we're not working with this broker. Now we will move to the legal obligations under the UAE anti-money laundering law, which is actually a great big step for UAE implementing the anti-money laundering regulations. It's very good step in relation to compliance, in relation to the banks, so they're more trustworthy in Europe and all over the world. So now the developers and real estate brokers companies, they are asked by the government, and actually it's a must, to do the due diligence for the client and collect the KYC documents, know your client documents. Why are they doing this? They are assessing the risk, looking for the people if they're under the sanctions or politically exposed persons, whether they can work with them or no. Each real estate broker firm must be registered with Go AML system, and online they submit suspicious transactions if they have something to say about this, or they show if they can work with someone or no, or maybe they work with a sanctioned person, but the sanctions were not related to the property, so they could work, but still they need to submit this information and Go AML system. As an investor, you must understand that it is important. Your documents will not go anywhere. They will stay within the company. They will not be disclosed anywhere else. So don't be scared to share a copy of your passport, utility bill, etc. It's a very small amount of documents. And also, if the developer or the real estate brokerage company is not asking you for any KYC, it's also a red flag, because you can already sign a Form F, the agreement for, let's say, purchase, and then suddenly the broker from another company, from the side of the seller, will say, oh my God, but you are sanctioned. You're sanctioned. We checked this in the system and we cannot close the deal with you, and then you will lose the opportunity to buy something, and you cannot do anything because you didn't submit your documents. So you need to be aware about this and be sure that it's nothing very serious, so nobody's asking for your bank account number here. I'm moving to the understanding the role of contracts and dispute resolution mechanisms. So as I was already talking about the off-plan, on-off-plan, you will have two documents when you're working with the developer. There will be a booking form and sale and purchase agreement. Booking form serves as the initial document expressing your intention to purchase a property unit from a developer. It is not registered with Emirate authorities. It's just an intention that you are a potential buyer, this is your interest, and normally it will contain a 2% from the total purchase price, which is not non-refundable amount. So the developer from his side can cancel this form if he doesn't want to sell you this property. But if you will decide not to buy, this amount will be non-refundable, and you need to remember that. The SPA is already legally binding contract. As soon as you sign it with the developer, within 60 days, it must be registered in HAQQ system. As soon as the SPA is registered in HAQQ system, it will show that you are the property owner and you continue to pay the payments within the installment periods, but you already know that you are legally registered in the HAQQ system in Dubai, and if something will happen, this is the property which you were registered for. One thing I would like to say about booking form and SPA, booking form must not include any payment plan. So there is only a reservation amount and nothing else. This reservation amount will go to the corporate account of the developer. Though when you're paying through the SPA, then all the installments are going to the escrow account, which will be included in your SPA. And then bank number and all the information will be there. If you see a booking form which has not only the booking amount, but also the full setup of the payment, like scheduled, you need to pay it after 2 months of signing of booking form, you need to pay this, after 6 months that amount, run from there, because this is illegal. Booking form cannot take any payments from you except the interest payment that you would like to buy something, that you intend to buy some units, and that's it. So we are only paying to the escrow account. This 2%, no problem, it's fine, but all the other amounts should be included only in SPA, and your payment plan should be paid only after you sign the SPA. If you didn't sign an SPA, the developer has no right to ask you to start to pay the payment as per the payment plan. There is no SPA, I'm not paying any further payments except the booking form. For the secondary market, here we have a few documents. I mentioned Form A, seller and broker, Form B, buyer and broker. There is also Form I, between agent and agent. If two different agencies representing seller and buyer, they need to have a contract between them. The most important one here will be Form F, also called Unified Sale Contract, or MOU. This is already a legally binding contract between you and the seller, or you and the buyer. If you want to cancel it, you will need to pay a penalty of 10%, or you need to, if you can mutually agree that you are canceling this contract without any payment, you need to keep this in writing. And for canceling Forms A and Forms B, you should sign Form U. Just give a 7 days written notice to the broker that you don't want to, let's say, sell or buy through them, and you cancel these forms. But you need to keep a high attention to the Unified Sale Contract F, which will include all the information on your property, who lives there, is it mortgaged or not, if there's a tenant or not. If there's a tenant, do you agree that he will stay there, or the seller need to give an eviction notice, or he promised you that he will evict? Also in this Form F, it's drafted by the government, it's drafted by the Dubai Land Department, it's half in English, half in Arabic, but at the bottom you have an extra part for additional conditions where you can add extra information, whatever you want, whatever you extra agree to, or you want to overwrite whatever clause from the Form F. So you can include it there. It's also allowed, so you can make slight changes if need be. Dispute resolutions in property transactions. First of all, we have a rental dispute center. Rental Dispute Center Committee. This is a center which handles the rental disputes between the property landlord and tenant. It's also including free zones, but not all, because some free zones like DIFC, they have their own jurisdiction and courts which will be resolving these issues. So when you have any problem between you and landlord or you and tenant, you can file a complaint at Rental Dispute Center. First, you will be asked to amicably settle your situation within 15 days, or if you want, you can proceed with the hearings for the first instance department, appeal, and execution department. So also the RDC is not authorized to handle disputes involving long-term leases. So it's a short-term lease, usually for 1 year and renewed, and nothing to do with the financial lease agreements. Everything else, including the sale and purchase agreement or Form F on the secondary market. Everything will be handled by the Dubai courts if it will be the last instance for you, if you will not agree to anything with another party, if they will not reach the amicable settlement. Property handover and legal hiccups to avoid. We'll give a small, short, I mean, not small, but short information on the, again, off plan and the secondary market. So when we are buying something on off plan directly from the developer should give us the SPA. Within 60 days, they should execute. Within 60 days of execution of SPA, the developer must register this SPA with the HAQQ system. On the handover, they will allow you 30 days for inspection, and then on the final transfer, they must register a title deed where you will be the official owner of the completed property. Option number 2, you have a property, you already purchased property on off plan, and you want to resell it, as I mentioned, after 30 or 40% of payment from the total amount of the property, you will be able to do so. For instance, if you want to sell it or you have no more money to pay as per the payment plan. So the seller, if you are the buyer, you need to ask the seller to show you the SPA. You will need to sign the form F between the seller and the new purchaser. The seller must obtain the NOC from the developer. The developer agree and allow the seller to sell this property, and it will also include any additional information, how many outstanding payments there are. And then the developer will sign the SPA already with the new purchaser. So we here have 2 contracts, Form F and SPA. And then it's the same on the completion. You have a right to inspect, and then the developer will need to register title deed for you in the trustee office. For the secondary market, is a bit lighter. The seller must have a title deed, again receive an NOC from the developer, give you a clearance certificate for unpaid service bills or charges. So here you will see if there is something outstanding there. So you will not buy a frog in the box or some unknown thing and which will come with the surprise. You will sign Form F, and at the closure of the deal, it will be all settled at trustee office with the title deed. This here I flagged important parts which I already spoke to. Inspection covered. Importance of registering the title deed with the DLD promptly. Why? If you sign the SPA, but the SPA is not registered with a HAQQ system, you are not considered as the owner of the property. If, let's say, you will have a court case, you will not considered as the owner of the property. So be sure that the developer will register SPA within the HAQQ system. And for the handover, it's always required on a plan when you have a handover to be presented in person and get receive the keys and sign other outstanding documents. But if you are not here and you cannot come physically yourself and you cannot be presented, you can always appoint a POA who can be a trusted person here in UAE, or if you don't have anyone here who can come and help you with this and you don't trust someone, some third party to be a POA, you can always approach a law firm who will help you to draft a POA. Plus, the law firm will appoint one of its employees to be a POA on your behalf. And this is the safest way, I think, for the seller or the buyer to be represented, because it's connected to a law firm. This is the common legal pitfalls during handover. I spoke about everything already, about 12 months, additional inspection 30 days, etc. I just want to say here for the slide that try to negotiate everything, try to communicate, try to mutually settle all the problems, because you don't want to go to the last instance Dubai courts and then spend about 12, 14 months paying different lawyers, paying for translation, wasting your energy, your time. As soon as you open the court case, the property will be blocked, so it can be only rented out, but it cannot be sold. And then it's a very big stress. So try to remember what's mentioned here in my presentation to avoid this uncomfortable process with the courts. Here for off-plan, additional service charges or fees during handover that suddenly can appear. So the only amounts which must be paid by you as the buyer during the handover, it's the outstanding payments as per the payment plan and relevant penalties if you are late with the payment. Everything else related to electricity, water, service charges, it's not related to the buyer. unless you received the property, you received the title deed, and only after that you're responsible for the payment, whatever payment occurred after you received the title deed. Everything you received, all the payments before the title deed received, is the responsibility of developer and his contractor. So you should not pay any penalties which were years ago or months ago and you didn't even know about them, and this is not your responsibility. Be aware of that, because I also have seen this already when developer was trying to put these charges on the new buyer. Long-term legal consideration for end users and investors. So what do we need to remember, first of all, about the obligations of the owner of the property? The owner can own, rent as he wishes. If he is renting out the property, he must cover the major maintenance and repair, which is usually goes above 1,000 dirhams. And surely he can sell it to anyone he wants to. There is also an option to get into the owners committee of jointly owned property, but usually it can be done only on the start of so when the completion of the building is done. You can apply through RERA to be a part of the owner committee, but there are only 9 people allowed to be there. And surely if you're buying on secondary market, you probably will not get into the owners committee because probably it will be already taken by the other people. But you can, if you bought a property and there is an owners, surely there will be owners committee. You can ask them to help you if you have some issues and you're not happy with the management company, because they can deal with the management company. They can receive complaints as well. And if the management company is not working well, they can request the replacement of the same management company. Talking about lease and tenancy laws, here we have some rights and obligations under the tenancy law for rental property. So thing number 1, if we're talking about the rent, you will receive a tenancy contract, which must be registered with Ejari system. If it's not registered with Ejari system, we cannot even connect Diva. So we cannot have electricity, water, and stuff. The landlord must ensure the property handed over in a good condition. He gives the full rights to the tenant. He's not allowed to come anytime he wants, break the doors, change the locks. And one more very important part, sometimes some landlords trying to include the service charges in the tenancy contract for the tenant to pay, but this is not the responsibility of the tenant, and service charges must be paid by the landlord. For the tenant, sure, you need to keep place in a good condition. Illegal use of the property is not allowed. Subleasing is not allowed unless you agreed with the landlord in writing. Bounce check, sometimes it happens. Usually the fine for this is 1,000 dirhams, and you need to immediately pay this amount in cash or do one more check. You're not allowed as a tenant to do any maintenance or restoration if it's not agreed with the landlord in writing. So you can use it, good, everything is fine. No illegal actions at the end. Pay on time, which will allow you to stay as long as you want in the apartment. If the landlord is happy with you, he will continue the tenancy contract easily. Quickly covering on eviction rules and rent increase. There is a specifics for eviction here in Dubai. So the landlord can evict the tenant when he gives an eviction notice. And even though it says in the law by email or public notary, right now the practice is only should be done by the public notary. The document will be in Arabic, the eviction notice. It must be accompanied with the English version, or maybe if, for instance, like me, I'm Russian speaking, some Russian people, they don't even speak English. If you have a chance to also accompany with the Russian version, that will be better, because the tenant can say, I don't understand Arabic and I don't know what I received. So this eviction notice must be given 12 months in advance of such eviction. And here is the most important part. Such period, this 12 months, will start from the new date of the tenancy contract. So not when the tenant received that eviction notice, but will start from the new date of the tenancy contract. So in general, if I'm renting right now and I'm renting this property for 3 months, let's say, but my contract is for 1 year, and I received an eviction notice, I have 12 months more on top of it, on top of my contract, so I can stay here for 2 years. If a tenant wants to include some extra terms or change the terms together with the landlord, or the landlord wants to change the terms, to the tenancy contract, they need to give 90 days notice to each other to just agree on what they want to change and bring it in the new tenancy contract. If tenant wants to evict the property, he will need to give the 90 days also notification in writing that he would not continue the contract. If he wants to terminate the tenancy contract earlier, normally, but it's not by law, but normally it's written in the tenancy contract, you must pay 2 months penalty on top of that. If suddenly the landlord will decide to increase the rental price, here we use the RERA calculator, which shows what's the current rental price for the unit where you live at. And as you can see here, you have a breakdown when it can be increased. So maximum increase for the next year can be 20%, but I think it's almost impossible because you cannot rent the property which is already rented out 40% above as what you're paying. So 20% is the max. If you are below 10%, you should not agree to any increase if you don't want to. But if it goes together with the calculations shown here, then the landlord will have a right to give you an increase or propose you an increase, and then you have a right as a tenant to agree or disagree and debate a little bit. Very quickly, we'll talk about inheritance because it's very important. I know we almost don't have time. So here we have the option. As you know, the UAE is a Muslim country, and for inheritance for the Muslim people, we are always using Sharia law. We need to be compliant with Sharia, and Muslim people, they can decide where their assets will go and how it will be divided as per the Sharia law. For non-Muslim expats, we are not using Sharia law. We can request to use the laws of the home country to govern distribution of the assets in the UAE. So basically, it's the will which was drafted abroad, but this needs to be done via Dubai courts. We need to translate all the documents, notarize, legalize, and prove that we are those ones who are going to inherit. Proof of the relationship we need to provide. If there is no will at all for non-Muslim individuals, the Federal Decree Law number 41 of 2022 will be used. And here I have a brief information how the assets will be split. So I'm not going to stop here. We will straight away go what to do if I actually want to distribute my assets as I want to do that. So here is a very big option in UAE. We have DIFC Will Service Center for non-Muslim to draft a will and assign your assets to anyone you want. It will cost you about 17,000 dirhams. Easy. No need to do anything after that. Everyone is happy. Dubai Courts Notary Will, also for non-Muslim. We have Abu Dhabi Judicial Department for both Muslim and non-Muslim. Sharia compliant will, as I mentioned already before. UAE will with letter of consent only for the Muslim. And there are also options to set up a foundation, which will help you to protect your assets and distribute them in the way you want as the founder of this legal entity. Summarizing my presentation, I would like to stress out again, please save it, make screenshots, think about the due diligence, how you work with the broker, how you work with the developer, which documents are essential, what is your responsibility as an investor in relation to the fraud and AML laws, and dispute resolution options. Don't drag it to the court. This will be the most difficult and lengthy process. And for the long-term consideration, please, I'm begging you, draft a will. Thank you for your time. This is my details, contact details, if you would like to contact me for any further legal information. As you can see, I have a QR code here, and if you scan it, it will be valid. Thank you very much.
Thank you very much, Veronika, for this explanation. Thank you for the all the details you provided, and most importantly, the key takeaways towards the end of your presentation. So we got lots of comments that this is a very informative talk, especially that the real estate sector in the region, and especially in Dubai, is tremendously inclining and getting a huge interest and impact. And we actually do have some questions. I will start off with the two questions that were asked during the like halfway through your presentation. First of all, Under what circumstances can either party terminate the SPA, and what are the associated penalties over refund policies? So under what circumstances can either party terminate the SPA, and what are the associated penalties or refund policies?
So the developer can terminate the SPA only if the buyer is not paying, is not following the payment plan. So surely you can drag it for a long time, because this is the most important. What I mentioned is negotiation. You can say, this is the situation. I'm trying to solve this delay. I will pay on whatever, I don't know, in 2 months and 3 months or whatever timing. But if it's lasting very long and you're not paying for this property, then the developer has a right to cancel your SPA. But usually the developer is more interested in giving you extra penalty at the end, rather than just to terminate the contract with you. And the developer will have a right to sell your apartment, and then what you will receive, it's the amount, depends on the construction process. So there is a split between 20% completion of the construction, 40, 60, 80. So the maximum amount that the developer can take from you as the buyer is the 40% from the full sale price. But then also the buyer can cancel the SPA, but this needs to be done actually through the court if the construction took more than anticipated completion date plus 12 months on top of that, and that nothing is happening and the building is not finished. Then you just stop, or at some point you can stop paying as per the payment plan, but then still you need to open a court case. But you just stop paying, so it's already, you're not doing this and you're opening the court case. So the buyer can also ask for termination of the SPA, for instance, if he cannot pay. But there are also options. If the buyer cannot pay anymore, he can say, okay, I promise I will, within 2 months or 1 month period, with the help of the wherever real estate brokers from, I will find another buyer for this property. So you can always negotiate, find another buyer for the same amount, or I'm almost like, if there's really somebody else who is ready to buy from you, you can discuss it with the developer. So, but if okay, you have no money and you cannot, and basically you cannot pay anymore and you cannot sell it to anyone, there will be penalties in the SPA saying what amount of money you cannot get back. Some SPAs even say that everything you paid, which is actually not correct, but that's what they do sometimes, that everything you paid is non-returnable, something like that.
This just added one more question I had in mind, but I'll ask my questions towards the end. So another question also from Jennifer, who asked the same first question. How should investors manage their duty of care when purchasing off-plan properties to avoid potential risks?
Well, there are always potential risks, but what you can do, as I said, you need to work with the developer who is registered, with the project which is registered and has a registered number, the project where you have an assigned escrow account, and try to Google the developer, because those ones who are very famous big developers, they usually have no problems with the completion. But anything can happen anytime. But surely if it's super small developer and nothing is known about that developer, you cannot do anything. But in any time, anything can happen. I don't know, there is a crash inside of the developer's company, there is a fight between the shareholders, and here we go. So the most important thing is license, registered project, registered developer, escrow account, and a famous developer.
Okay, thank you. We have another question from Ahmed. How can I make sure the tenants for my property are paying the utility bills on time, so that I avoid these charges to fall on my responsibility as an investor?
It's first of all, it's not the responsibility of the owner of the landlord of the apartment to pay for the bills of tenants. So if the tenant is not paying the bills, the electricity will be shut off, or there will be no water, and actually the landlord will receive this information. Because that's why we registered the contract in a JARI system. So the landlord, the owner of the apartment, can contact the HRE and ask like what's happening. So he is the person who is he is the one who can communicate with HRE and the department which registering this. So if so the tenant, first of all, he's gonna pay you the rent and by the checks, but if he's not paying the utility bills, it still will be his responsibility, and there will be a case surely when we can open at the rental dispute center, but because it's the jurisdiction, so it will not be a court. So there they will oblige the tenant to pay these bills, and will never come to the landlord. Even like you will not terminate the tenancy contract, you will just prolong it and continue until they pay.
Speaking of the Ijari system and the contract, who is responsible for registering the Ijari contract? Is it the landlord or the tenant? This is another question by
yeah,
Ahmed.
originally it was for the landlord to register Ijari and to cancel it at the end when the tenant is evicting the property. But what's happening right now on the market, you have a tenancy contract, and in the tenancy contract, it clearly states that this is your responsibility as a tenant to register the Ijari. So they just put it. So you need to look through your tenancy contract. If it says that it's your responsibility, then you must do it. If you sign, whatever you are signed under, it's your responsibility. So that's why you need to be very careful with the drafts and read them.
Okay, thank you. And one more question from Tarek. With this market rising at the speed we are seeing today, in your personal opinion, Veronika, do you think we will be seeing more strict regulations and compliance in the years to come?
I think the regulations are already strict, and actually the compliance as well, and anti-money laundering law is working very strongly. I saw the penalties coming from the government. The government every single year or twice a year, depends on the company, they're checking how compliant is the company, and like they will come to your office and check all the documents, see if you're keeping KYC and stuff. So it's already very strict, and already I know a lot of companies who receive the fines. Normally is 150,000 dirhams for the start, but it can lead even to revocation of the license. So the government can even take your license away if you're not compliant. So what can be more strict than that, to lose your license?
Okay, so and I have a question. You like towards the end of your presentation, you spoke a bit about the rules on inheritance and differentiated between Muslims and non-Muslims. Are there like special laws or regulations that handle with the joint ownership of property in Dubai, or it's not something that's very common?
Normally, if it's jointly ownership of the property, it will be shown in your title deed. So if it's possible that 2 persons or 3 persons own the same property. So yes, it is here at place. So that will be a little bit more difficult for the will, but you can only assign your part of this property to somebody else. You cannot assign the part of another person. Which is also mentioned in the title deed to somebody. Same as you cannot sell. If, let's say, there are 2 owners on the same property, both of them should sign the sale and purchase agreement, the Form F, or one of them needs to give a POA to another one, because you need an approval from all the owners to sell, let's say, the property.
Okay, thank you so much, Veronika. I think that's it for the questions. Again, thank you so much for your insights, and I'll make sure to reach out if I have any questions or potential clients relating to property in Dubai and everything that relates to the real estate market over there. And I'd like to thank you and the firm for this presentation and your time, and all the attendees for staying with us. I hope it was beneficial for everyone.
Thank you again, and I hope that my input will be very useful for the people who are watching us and will help them to avoid difficult situations.
Hopefully. Thank you so much, and take care, everyone.
Thank you.
Bye-bye.